Good morning, everyone. Today is August 13th, 2020. My name is Shana Horton. I'm an attorney for the TABC, and we are here today for an informal stakeholder meeting regarding two rule packages that are coming up for proposal. The first item is the amendment of Chapter 33, subchapters A, D, and creation of subchapter F, which is essentially about reorganization of Chapter 33. The second item is a new subchapter regarding events at temporary locations, which will reorganize existing provisions and also add some new provisions due to legislative changes to temporary event authorizations. We have a lot to go over today. I'd like to spend half an hour at the most on the first item. It is essentially reorganization. If you open up the documents that are posted on board docs, the subchapters A, D, and F markup, and the crosswalk for subchapter A, D, and F, that will be a helpful thing to look at, as well as the Chapter 33 TOC, Table of Contents, for that first item, so we can discuss that and you can have some reference as we do. The second item is a new subchapter. There's a lot in it, a lot to go over. So when we get to that, I will go over it, but at the end there will be time, of course, for questions and conversation. And the way we're going to do that is, if you will note on your Zoom meeting, you have the ability to raise your hand. And so if you have a comment or a question, if you could please raise your hand. Joe will unmute you. When he does, please state your name, who you're representing, and then your comments. And we have a lot to go through again, so be mindful of the time. And then if there's a question, I will try to answer all of the questions. If there's something that I can't answer, I do have subject matter experts that are available to help me answer those questions, folks that work in those particular divisions. And then if I'm not able to answer your question today, I would really appreciate it if you would send me that question by email. That will ensure a response. My email, of course, is shana.horton, shana.horton, @tabc.texas.gov. So if something remains unresolved at the end of the day and you still want to chat about it, please do send me an email and I will get back to you. Okay. With that said, let's go ahead and get started on item number one. If you look at the table of contents, which is one of the documents that was posted on board docs, and if you've been paying attention to rules, which most of you have, you'll have noticed that we've made changes to a variety of the subchapters in Chapter 33 due to legislative changes. We were touching on so many of those chapters that we decided it would be a good time to reorganize that chapter in a more intuitive way and to make a little more space for some of the new provisions, and also to sort of standardize what our rules look like and how they flow. This item number one, the amendment to chapters A and D and creation of subchapter F, don't do anything substantive. Rather, they rearrange things. For example, subchapter D, we've moved the single provision that was there into subchapter A, and the new subchapter D will be the application review and protest rules that we discussed at the last meeting and the meeting before that. So if you put together all of the pieces that we've been working on over the past several months and that we will be working on tomorrow and today, you'll see that we have we've basically touched every subchapter, and so we are reorganizing. You have a crosswalk for subchapters A, D, and F, which shows where those provisions came from and where they went, and you have a markup. And I hope those documents were helpful for you. One thing you'll notice, and if you look at the table of contents, it'll be very clear, and this is something I've been doing with all of these rule packages as we draft them, is putting them in a more standardized order and format. Your rules will typically start with an authority or scope or applicability section, Then there will be a definition section if it's necessary. Then that will be followed by provisions that are general. In other words, they apply to either all permittees or all the permittees that are covered under that chapter. And then you will have your provisions that apply to only certain permit holders or certain types of situations broken out at the end. With that said, I don't think there's a whole lot to discuss with regard to these, moving these sections around. But if you have any comments on the reorganization of subchapters A, D, and creation of subchapter F, now is the time to discuss that. Or if you have any other thoughts about the overall reorganization of Chapter 33 as you see it in the table of contents there, I'm happy to answer those questions and field those comments as well. So the floor is yours. Okay, I'm not seeing anyone raising their hand. If you are having any trouble finding the raise your hand button, you just want to type into the chat and tell us that you'd like to make a comment. You can also do that. I don't want anyone to get left out or have any comments left behind. Okay. It looks like there's no questions or comments about item number 1 at this time. If you think of something later, today's the day to talk about it, so feel free to bring it up later on. That said, we will move to the new subchapter for temporary event permits. Oh, I'm sorry. We do have one. Is that Mr. Schwartz? You have been recognized. Please state your name and who you represent, and then give us your comment. Unmute. Hold on just a moment. We're trying. Okay, you need to unmute yourself, Mr. Schwartz.
Oh, unmuted. Sorry about that.
There you go. Okay, perfect.
Technology. So, apologies. I do have one question in relation to some added language, and on the crosswalk it says that this appears, I think it was non-substantive, but 33.3 subsection H is some new language. And I just had one question specifically in the last sentence, why the word major is in there, other major categories. Right now with licensing, we only do food, alcohol, and other breakdowns. And I was just wondering, does this mean other is going to be broken down into various different other categories?
33.7B.
Sorry, 33.3H.
It moved from 33.7B is what I'm seeing. Let me look at this crosswalk.
Oh, well, it may be that way in 33.7. I just caught that for the first time.
Yeah, you know, that's, I didn't change that at all, so it's not something that we discussed changing. It's exactly as it was in 33.7B. It's just been moved. So that's no change. Gotcha. But if you still have that question, that's something that I'm sure permitting can field, maybe by email.
No problem. I should have realized that was just a full cut and paste.
Yes.
Thank you.
No problem. Okay. Do you want to unmute Amy? Amy Harrison says, please go over the new sections on the crosswalk and please explain the thoughts behind the new stuff. Are you meaning on item number 1 or item number 2?
Hi, this is Amy. I was just hoping that you could go over the new parts on the crosswalk. This is a new document that a lot of us are not used to seeing. And it would be helpful if you could just explain the new text and how the new text was arrived at, if possible.
Okay. I'm just trying to get to that. I have a lot of documents open, I'm sorry. Okay, so $62.08. So this the new text on from 4157 has been moved to 33.4, and it has been amended. And I'm going to need my subject matter experts to remind me what we have consolidated there, or if it's just a change from 6208. I know it wasn't anything substantive, I just don't remember where we pulled it from. So if any of the folks that worked on this have any comments on that. And if not, I may have to get back to you. Let me look at the markup. Okay, so 33.4, we moved to 34. So the crosswalk is going to work in tandem with the markup. They show essentially the same thing, but in different formats. So the markup has explanations. It's all the existing warehouse regulations pulled from other places, from 4157. Is there a specific section that you're wanting to know about? The 33.13, which is now in 33.3, that change we removed maybe follows the county judge as mandated, because that county judges no longer have that role per Sunset Commission. On 33.31, now 33.91, changed administrator to executive director just for consistency. 33.32, updated a cross-reference and changed these rules to this title, again, just for consistency. It's the same thing. And 3334, now 3394, I've just updated the cross-references to work with the new Chapter 33 outline. So the only one that I can't specifically give you where those came from, but they are existing, is 33.4, and I can do that after this call. The only change at 3391 that I'm aware of is changing administrator to executive director. Is there something else? It used to be 3331, it's now 3391, and I changed administrator to executive director. Okay. 3331 And Ms. Harrison, I'm writing down that you need to know about 33.4, but if you could also just open up an email to me and type that in there, and anything else I can't answer so that I can look at it later when I get back.
I apologize. I guess what I'm not understanding is on the chart, and I'm looking at item 1, crosswalk, and up at the top it says new text. And when I start talking about 3391, and it has new red line text at the top of the column, and you say that the only change was executive director, is
Yes.
so C is not new, C is
No.
old. Please,
Exactly.
okay, perhaps if you could explain the form and just how that works, because
Okay.
like I say, there's a lot of people on this call that don't understand, so that would be really helpful. Thank you.
Okay. I understand the situation now. Okay, so where text is redlined, that is not going to be new text except for the red line. Where it says new text but it's not redlined, that's all new. So the whole thing is new. So for example, but of course by new I mean it's moved from somewhere else. None of it is brand new. But like 33.4, there's no redlining because that is all, it's all changed. So it all looks different. So it wouldn't make sense to redline it. It would just get really messy and ugly. So instead I've just said old text, new text. But yeah, where it's redlined, it's just the redlining. Yeah, I'm sorry, that wasn't clear. Okay. Are there any other questions regarding item 1 or how the crosswalks work? Okay. And yeah, thank you for asking that. If anyone else has any questions about, you know, the format or how we're using these documents, I'm happy to answer that. I realize that these are not necessarily things that you've worked with before, but I find them very helpful when you're looking for something, especially if these rules are adopted when you're looking for something later. You'll be able to find it quickly, especially those of you who, like Ms. Harrison, are very, very familiar with our current rules and will need to be finding things in different places in the future. So I hope they are useful for you. It looks like that there are no more questions on item number 1. So we will move on to item number 2, which is the new subchapter regarding temporary event authorizations. As you all know, sunset legislation changed some things and consolidated some things. A lot of your temporary event authorizations are going to be, or temporary event is going to essentially be rolled up into your 2-year permit, and we're left with just a few types of temporary events. Let me get to my notes. So what used to be called a notification is called now file and use notification. That really hasn't changed much. It should look just like you remember it. That doesn't require an application. It doesn't require pre-approval. It's a limited set of circumstances under which you can simply let us know that you're going to have the event. The second category, we've got a separate category for nonprofit entity temporary event permits. This is all nonprofits can use the same type of permit, whether or not they have an underlying 2-year permit, which I would assume most of them wouldn't. And they don't necessarily need to work with a person who holds the current 2-year license or permit. They can do this on their own. And then the third type is essentially everything else, temporary event authorization. So the terminology is it's a little bit confusing because there's a permit, there's an authorization, and there's a notification, and they are three different things. But at least it's only three things, and not a whole bunch of subordinates or other authorizations that are found in other places. So hopefully this will help everyone understand and be able to use their temporary permits. Let's see. You won't need subordinates like caterers and winery festival or other temps. This is all you'll need for a temporary event. Nonprofits are all rolled into one. I think for this one, I do want to go through and talk about, let me get all my, these changes will not take effect until September 1st, 2021. So even if we get through the adoption process before the end of this year, which we would like to do, they will not take effect because the statutory changes also take effect on September 1, 2021. So these are not effective for a little while yet, but we have so much to do in the meantime that we're front loading things. Okay. Getting my documents open. All right, I got them. Okay, so we'll just run through this quickly. As I discussed earlier, we've laid out this subchapter in the format that we're doing all of our new rules. There's scope and applicability section. Then there's classification of event authorizations, which is where you'll go to figure out which of these three types of authorizations you will need for your event. Term of the authorization, and we'll go back and do questions on all of these. I just want to run through it quickly. Term of the authorization, we're required to set terms. Some are set by code, and others we are required to set. So the number of days per authorization, which of course, if your event lasts longer than that, you can get more than one consecutive. Excuse me. And then a limit on the total number of permits in a year for the same permittee at the same place. And then we also have the ability for the executive director to make an exception to any of these limitations on a case-by-case basis. So there may be circumstances where the limitation on the number of days or the number of events is inappropriate. We don't want to hamstring those folks from being able to do that if it's absolutely necessary. And we can go through questions on that later. General provisions, these are things that have been moved from the other sections that apply to everyone. The reasons for denial. We are adding that we will let a nonprofit know if they have not been, or a temporary event approval application, we'll let them know if they're denied, or let them know the reason. That's something that we already do. You can see in your draft where each of these provisions came from. They've been moved around, but they are, for the most part, existing. We've changed the terminology. 3374, you're used to seeing, I think, expedited processing fee or something like that. That's now going to be called a late filing fee. But it's the same, has not changed. Penalties and suspension, 3375. The Sunset Bill required us to adopt some rules regarding cancellation and penalties that we can use to enforce compliance with this this section, with this subchapter. And so we have here some new provisions, but they're not new. Obviously we're not creating authority for ourselves. These are just provisions that take the authority we already have given by the code and explain them and express them in a rule. 33.76 is the rule specific to file and use notifications, and it lays out the current 33.12D qualifications. There's nothing new there. And yes, that all comes from 33.12. 33.76E, persons using a file and use notification must keep the following records for 4 years. That's currently in the licensing bulletin regarding file and use notifications, but we felt that since it's universally applicable, that it needed to be in rules, so we've moved it here. Then we have rules for temporary event approval, specific, and then specific rules for nonprofit entity temporary events. Finally, Rule 3379 is intended to capture what is currently Advisory 26. Again, there's a lot of nuances for how nonprofits and others, charities, religious, political, civic organizations can use alcoholic beverages at fundraisers, and because those are, again, universally applicable to those folks to whom they apply, we felt that it should be in rule, and so we have taken Advisory 26 and tried to capture what is in that here in 33.79, all of the things you can do and all the limitations. So that's where we're at. We're at, so 9 rules, 10 rules, and hopefully using the crosswalk and the annotated version of the chapter, you are able to see where everything came from and what is new. And so I'm sure there will be lots of questions. We have an hour and a half to talk about it. So I will give you all the floor and we'll get started. Let's start with, okay, is anyone raising their hand yet? No. Let's start with 3370. I assume there aren't any questions about that. It's very basic stuff. The rule relates to certain chapters of the Alcoholic Beverage Code, and it applies to all temporary events. And then classification of event authorizations, 3371. Are there any questions or comments about 3371 regarding the classification? You'll see that we've defined a nonprofit temporary event by using both 33.15C and the new code section 30.03 to make sure we're capturing all of the various words that were used to describe that type of event. In subsection B, I wanted to point out this is not a requirement but a consideration. If an event must be private and not open to the general public to qualify for file and use, and while it's not a requirement that there are no tickets sold or the event only lasts for 1 day, if either of those things are true, that is something the Commission may consider in deciding whether that event is truly private and not open to the general public, if tickets are sold and if the event is a multi-day event. It may lead to further inquiry. Can we explain what is private, not open to general public? Let me see if I can get Joanne or nothing has changed. We haven't changed anything about private. That is what is existing in the rule. So there's not going to be a change to how it's considered now. This rule doesn't make any change. I get, is there a standard way that the licensing division considers whether an event is private? Essentially, I would think private means by invitation only. But again, this rule hasn't changed anything about the language, so it won't change anything about the way we have been considering this. It looks like there's not an answer forthcoming at this moment, so I will write that down for further response. If you could please email it to me, I'll get it to the right people. Okay. Are there any other questions? Oh, okay, Joanne. Can you open up Joanne Joseph? J. Joseph. Okay, you are unmuted. You need to unmute yourself. Joanne.
Okay. Okay, thanks. Can you hear me?
Yes, ma'am, we can.
So typically a private event is like a wedding or, you know, an office function or, you know, a funeral to where that you're not, you know, it's not open to the general public. So that's typically what we say as a private event. So if there's other explanations that people want to provide to us that would give us clarity, then we're open to that also. But that's typically what it is. It's a private event. I know all these, you know, people personally. And so, you know, I'm having this event for those people that I know personally. But like I said, if there's other explanation for it, then, you know, we're open to the explanation of how it meets the qualifications otherwise.
Okay, so not advertised, no tickets sold, known guests only. And of course, if there's another explanation, we're open to hearing that. So there's case-by-case flexibility as well. Okay, thank you. Okay, let's move on to section 3372. This is limitations on the terms of the authorization, so minimum number of days, maximum number of days, and then a maximum number of events per year. We have provided explanations in the comment section. We have decided that all event authorizations will be effective for a minimum of 2 consecutive days. Essentially, that is because it's logistically difficult to do your drop-off and your event and your pickup all within one day, and so we'll go ahead and give you those 2 days to make sure you're covering all of the days that you have alcohol on site, not just the day of your event. We're limiting temporary event approvals and file and use notifications to 4 days. The code limits the events to 4 days for BGs, BEs, and wineries, but not MBs or private clubs. And so we chose 4 days to be consistent with all the other licenses and permits that are limited by the code. Subsection C, a person can use temporary event approval at the same location for no more than 10 events in a calendar year. What we're trying to get at here is, in order to be truly temporary and not needing a 2-year authorization, we have to have some kind of limitations. We can't have a person who is pulling a temporary event permit for every single weekend of the year at the same place, essentially to have a second location, but that's only open a couple of days a week. So that is intended to address that situation. However, we understand there might be situations where it's necessary, and again, that's why we've added subsection E for the executive director to have the ability to make an exception where necessary. The nonprofit event temporary permit can be effective for up to 10 consecutive days, and that accommodates events that span 2 weekends. And the rest of these subsections are precisely as they are elsewhere in our current rules. Yes.
Marcus would like to talk.
All right. Marcus Schwartz, you're on.
Marcus Schwartz, Bracken Schwartz PLC. I had one question in relation to the minimum 2-day consecutive days requirement. I know where you're coming from here. I will just say, for instance, I had this a couple of years ago, but the city did a parade, and for this event, they wanted one retailer to cater the event. And the event just so happened where they wanted to cater them was right in front of their restaurant, but it wasn't on their premises. And so they only needed it for a day because they just got everything at their restaurant and then wheeled it out and wheeled it back in. They didn't need wholesaler staging or anything like that. And frankly, the issue there being if it's 2 consecutive days, right, and they only have control over it for a day, what happens if there's some breach in that area the next day? Is that on them then when they don't have a right to that property any longer? So I think some flexibility there may be beneficial, not a hard 2 days.
Okay, I hear you. I will take that under advisement. I think, the situation that you're describing is probably the exception, not the rule. And so there may be a way to handle that differently. Or perhaps the answer is they need to maintain control of the premises for another day if under their contract. But we'll think about that. I've got that written down. Thank you.
Thank you.
I'm just writing that down real quickly. Okay. For the exceptions ED is allowed to make, are there guidelines for his exceptions? Are his exceptions documented for public information and consistency? There aren't any guidelines for the exceptions, but exceptions will be granted in writing, and that will be public information. But not tracked, will the exceptions be tracked and shared with employees? We haven't provided for that, but I'm sure that permitting would be notified because they're the ones that are going to be issuing that permit. So the employees who are involved with the issuance of the permit will be notified. I'm not sure how it's going to be tracked in the new AIM system, but if there's anyone who knows AIMS better that can tell me how the duration of temporary permits are going to be tracked in the AIMS system, please pipe up and let me know. Okay, Joanne. Joanne?
Yes, we're
Okay.
still, Ames, we're still, in the working and development stages. So we're not positive how that tracking is going to work, but we do have mechanisms for tracking. We're just not sure how it's going to work yet in Ames because we're still in development of those things.
But it has to be tracked for metrics, for performance metrics,
Yes,
I'm
yes.
assuming. So it will be tracked, we just don't know exactly how.
Right, exactly how.
Okay.
We don't have the specifics on that yet, but yes, it will be tracked.
Okay, and again, these don't go into effect until next September, 2021. So at that time, we should have the system. Is that when the system's supposed to be up, or is it December?
Partial up,
Okay.
we're going to go in stages, but for all of this, it'll be later. It'll be September.
Okay. Can everyone hear Joanne? Tell me if you can. Okay, so it will be tracked. There will be public information available. All right. Okay. Are there additional questions about 3372 regarding any of these limitations on the time period, the term limitations? Okay. If you think of something, we can come back. Amy Harrison asked, Section I, and how do they know what signs? Is that on the next provision? Yes, okay. We have moved on to 3373. The first question is, how do they know which signs? They're going to need to go look at the code sections themselves and see if that code section or the one section of the rules includes them. So that's going to require legal interpretation by each individual who is requesting a temporary event approval, according to the code or that one rule. And if any of the subject matter experts have anything to add, please don't hesitate. Matthew, if you want to speak, you can just, I see you're having trouble with hand raising. If anyone else is having trouble raising their hand, just type into the group chat that you would like to speak, and Joe is monitoring that, and we'll make sure and open up your mic. Question from Ms. Harrison, I think that's L. Many times TABC gives refunds for rained out events. Will this change? Joanne, do you have a response to that?
Oh, okay.
Sorry, go ahead.
Okay, sorry, I hit the button. I didn't realize you were waiting for me.
You're fine.
We, obviously we'll take into consideration things like that if we know in advance that things are going to be rained out or possibly canceled or something. We'll take those things under consideration, but not for any of the late filing fees. So
late filing fees will not be refunded under any circumstances, but if you'll see, I've actually carefully worded this to say that the applicant is not entitled to a refund or proration, just to leave the ability for a refund to be issued if that's the fair thing to do. So we're not prohibiting refunds here, just saying that there's no entitlement to it. Yes, I hope that answers your second question. It isn't no refunds, it's just no entitlement to refunds. However, if it's a fair thing to do based on the circumstances, we won't change our habits and our practices in that regard. Are there additional questions or comments on the general provisions that are applicable to all of these permit types? Okay. Late filing fees, again, we've just kind of switched around the terminology from expedited processing to late filing. It's more of a deterrent or an incentive to file on time, and so that's it, just describes it better. But the fees have not changed. For the same types of events, you will have the same types of, or the same amount of days to file, and if you're 10 days to file, and if you are within that 10 days right before your event and you haven't filed yet, you're going to be subject to the same late filing fees as you have been. Are there any questions about the late filing fees? Okay. 3375, penalties and suspension. Again, the Sunset Bill required us to adopt rules for penalties and enforcement of these temporary event authorizations. And so what we've put in here is nothing, it's not new authority. We don't create our own authority or anything like that, but it is taking the authority that we've been given by the legislature and putting into rule how we intend to exercise that authority. So the executive director can cancel an authorization under the subchapter regardless of the expiration of the temporary authorization. So if there's problems in the middle of a 10-day event, that event could be canceled in the middle. If subsection C, if there's an entity or a person that's using temporary events on a routine basis and they have certain types of serious offenses, such as sales to minors and not or sales to intoxicated persons, then the executive director can suspend their right to apply for up to a year. In other words, you're a bad actor, you don't get to pull any more temps for some set period of time, and then you can come back and start doing that again. And then, of course, we may assess an administrative penalty for violations of the code or rules for events under this chapter in the same manner as 2-year permits. Question, 2-year permits, Ms. Harrison asks, is this only about 2-year permits, or aren't MBs able to get a 1-year permit now? Is there a subject matter expert that can respond to that? All right, Joanne. You're on.
Okay, so we're still in 2-year permits. What happened with this governor waiver was to allow for mixed beverages within a certain time frame to renew within 1 year. So we're still on our 2-year renewal time frame.
Okay, so renewed permit is still going to be a 2-year permit.
Yes.
They can just come in earlier.
Well, no, I mean, the governor waived for mixed beverage permit holders that expired at a certain time that they could renew for 1 year.
Okay,
But other than that, we have not exercised any 1-year permit terms other than this governor waiver. So our permit terms remain 2 years.
okay, okay. That's something we may need to follow up on, because we don't want to leave out the holders of any of those 1-year permits. However, remember, these don't go into effect until September 2021. So will there still be 1-year permit holders at that point?
No, after this one, when they come up for renewal again, they're going to have to renew for 2 years. So
Okay.
there probably
So there won't,
it's more than likely there won't be any, depending on how long this waiver lasts.
okay. That sounds like something, thank you for pointing that out, Ms. Harrison. That sounds like something we might need to look at more closely, since there are these 1-year permits under the governor's waiver, and we don't want to leave those people out. I'm going to make a note of that right now. Okay. Other questions? Yes.
Marcus.
Mr. Schwartz?
Yes, Marcus Schwartz, Bracken Schwartz PLC. In regards to subsection B and cancellation, is the idea that these are kind of special one-off deals so they will be handled on a case-by-case basis? Or is the idea that we would try to apply the standard penalty chart for various violations for 2-year permits and we try to do the same for these? Or
No,
what's the thought there?
that the standard, yeah, no, the standard penalty chart, I don't believe it's the intention to apply that. These are case by case because they are very different from a 2-year permanent event or permanent premises. And correct me if I'm wrong, anyone of my subject matter experts, but I believe these are one-offs, and so that it's just going to be a case-by-case decision. And obviously, cancellation in the middle of an event would have to be for egregious, pretty egregious conduct or violations. And we're not going to shut you down for not having the right sign. We'll have to just have you put up the sign. So that will be discretionary. Okay. Yes. So not the standard penalty chart, just a case-by-case decision.
Thank you.
Ms. Harrison asks, if I get temporarily suspended, does the process go through SOA? Do administrative rules apply? No. If you are suspended and you want to contest that, the method would be through an appeal of the executive director's action to district court because it is a final action. And the reason, one of the reasons for that is that, of course, the temporary event, if you're going to SOA, it's going to be, over by the time you get there. So it would kind of neutralize the impact of any suspension. So that would be something that would be taken up in district court. Additional questions or comments on the penalties and suspension? Matthew. Matthew Cherry would like to speak. Are you
Uh,
unmuted? There you
Yes,
go.
can you hear me? I was just going to add that some of the reasoning behind that is because some of the businesses that this is applicable to don't actually hold any other TABC permit because they are businesses that for the first time are applying for the nonprofit temporary event permit. So there's not a lot of authority or an avenue to do much to a bad actor that obtains that doesn't have some other primary permit. So some of this is specifically trying to address those types of scenarios with those businesses.
Folks who don't hold any other permit. Okay, thank you for that clarification, Matthew Cherry. Okay. Looks like we can move on to section 3376, file and use notifications. As I said, this has been, things might have been kind of moved around a little bit, but this is current, these are current rules. Or in the case of subsection E, it's currently part of the licensing bulletin 4. Are there any questions regarding qualifications for file and use? Requirements, record keeping. And again, of course, the record keeping requirements are, because this is a notification, the only method the agency has to ensure compliance is essentially a back-end audit. So we need to have access to those records to ensure that file and use is not being abused by folks who aren't actually eligible to use it. Ms. Harrison asked, if someone uses the file and use and it did not qualify and they should not have used this method, is there a penalty? Yes, that's the type of thing that we would penalize under 33.75 because that's essentially having an event without the necessary permit. So that actually might go under I would think that would end up under the regular penalty chart because it's a violation for not having a permit for an event that required a permit. Additional questions or comments about file and use? Okay. Request for temporary event approval, Rule 33.77. Again, this has been sort of cobbled together from other spots in our existing rules. It's mostly procedural. You need to file on our form. You need to file it at the event's email address. So we're going to have specific email addresses or through the online portal. Payment of late filing fees is required. We may request other documents. And then for this one, the temporary event approval will show on its face the effective dates for the event. If that's required for nonprofits by the code, and we decided that that makes sense to extend that to the temporary event approval. Payment of the fees for, Ms. Harrison asked, where will payment of the fees for the nonprofit entity, for the temporary event approval be remitted? Does Joanne or anyone else have an answer for that? For example, if you're applying through the portal. Okay.
Yes, if we're Ames and up and running, which hopefully we will be by the time this is effective, then the ability to pay online is there. We don't encourage it, but we'll still, you know, if people have no other means of doing it, then we'll accept the, you know, paper checks or paper documents, but we encourage it all to be online.
If someone needs to pay by check, would they do that to headquarters or to their regional office?
Yes, ma'am, directly to headquarters.
Okay. Just, hopefully that answers the question. And hopefully most people will want to do that online. That can just make everything more efficient for all parties. And again, temporary event approval is kind of your catch-all. It's going to be used for anything that's not eligible for file and use and not eligible as a nonprofit entity temp event. Okay. Okay, Ms. Harrison's raising her hand. Okay, you are.
Thank you. Thank you. I appreciate it. I'll be quick. 33.7, request for temporary event. So we know that it's going to be made on the forms. We know that it's going to be emailed. So that tells me that Ames is not going to allow or is not going to allow for an online submission, because in B, we already know that they're going to email to the email address for the TABC region. If we know those two things, that there's going to be a form and we're going to email, I don't know why we don't know how money would be submitted. If, you know, so the requester shall remit payment. Well, that's part of the problem now, is payments getting lost because, well, pre-pandemic, because people didn't know where to remit the payment. So it would just be my suggestion that if we know specifics about Ames and we're really trying to pass rules before we know our system, then perhaps we should say the requester remits payment somehow to headquarters, just so that we could be as specific in this section as we are in A and B. That was just a suggestion. Thank you.
Okay, I've got that written down, and we will consider that change. Yeah, we're all struggling with trying to write these rules with a lot of things still moving. So I appreciate that. Okay, there are no additional questions on and subsection B. It does say that a form can be emailed, or if they have another permit or license existing, they'll have they'll have an account with us in Ames, and they can submit through the online portal, and that will have the ability to pay online. So what we're hoping is that the vast majority of folks will already have a permit. They will have an online portal to go through, and we'll do it that way. If they're getting a nonprofit entity temporary event permit and maybe don't have another permit with us, then email to the form to the TABC region, and then and you know what might be a good idea is instead of putting that in rule, adding it to the form where payment should be remitted, and that way if there is any change to that, we don't have to change the rule. So that might be a good way to address that. Okay. Okay. Okay, and then Thomas Graham has informed me that Ames will also be able to take nonprofit entity temporary event permit applications, but it'll be a little bit later as it's being rolled out in phases, as Joanne mentioned earlier. Okay. Let's move on to nonprofit entity temporary events, section 3378. This is primarily pulled from current 3311 or new requirements from the changes to, new requirements from the Sunset Bill that are in Chapter 30 of the Code. The exception, well, yes, I think that's true for this entire, for this entire rule. Nonprofit entity is defined as defined by the code. Again, you'll have to make your application on forms provided, email it or email it to the TABC region, remit fees. I think, again, the same problem, I see that the same issue is there with where to remit fees. So we will think about how to address that issue because obviously we want to make that as easy and understandable as possible. Some of the other standards, in addition to application forms, we may request other documents. If we issue you a permit, it will show on its face the effective date. That's required by the code. Let's see, permit holders must purchase distilled spirits from nonprofit entity entity temporary events from a local distributor permit holder. That is new and it's required by code. We've added a little reminder here that events in dry areas need to comply with section 30.09 of the code, but otherwise we are not, we have the ability to, but we are not choosing to limit the number of events a nonprofit entity may hold under this section in a calendar year. Okay, the fee, the rationale for the fee. Temporary 2,260 temporary certificates were issued to non-licensed entities, about $440,000, so $200 for each nonprofit event. To be consistent with the limitation on the number of days for two-year permit holders, 4 days, that would come out to $50 a day. So that's how I came up with that, is based upon a revenue neutral approach. What amount we need to collect per day to maintain the same amount of income to the agency, revenue to the agency from these permits. Are there questions or comments about nonprofit entity temporary events? Is there anyone here? Okay. Question from Ms. Harrison, is a nonprofit entity permit holder a permit holder or a nonprofit entity temporary event permit holder? I'm not sure not sure what the difference is. Can you explain further? If you'd like to be unmuted, we can unmute you. What you mean by, are they a permit holder or a temporary event permit holder? Will you please unmute Ms. Harrison? Okay.
So an NE is a nonprofit exempt organization. So an NE is a permit holder. So if I'm a VFW, where do I fall? If I'm a VFW that's currently permitted, I guess I'm just confused, and maybe I should review 30.01 better. But
I think we might be able to answer your question. Matthew or Thomas? Matthew Cherry or Thomas Graham?
Amy, are you talking about if the business itself is already an existing nonprofit?
I'm a VFW that holds a private club exempt permit, an NE. And
Got
I want to have a private event, or I want to have a nonprofit entity. All of my events are nonprofit.
Right, because
So-
you, as the permit holder, are already a nonprofit entity. In that scenario, there wouldn't be a requirement or really a need necessarily to go and obtain the NETI because they already have a primary permit with their private club. And with the new authorities, they could then just obtain the temporary event authorization to conduct that private event at, another location. I could envision some scenarios where they may want to partner with another nonprofit, and that nonprofit then goes and obtains the NETI because they may want to have another business be the entity that controls and handles all of the sale and service of alcoholic beverages at their event. But outside of that, there's really wouldn't be a need for them to go and obtain the NETI because they're already going to have authorization.
Matthew, what's a NETI?
That ends up how I pronounce the acronym for the nonprofit entity temporary event permit, NETE.
And so is that the slang word that the commission's going to use for this type of permit, the NETI?
I can't say that I'll hold anybody to that. As I read through things, that's how I pronounce it currently in my head.
Okay. You just used it a lot, so I wanted to make sure that we all knew what a NETI was. Okay, awesome. Thank you.
Thank you, Matthew. Are there any additional questions or comments regarding nonprofit entity temporary events, draft rule 33.78? Okay. I think Thomas might still be unmuted. Yeah, mute Thomas so his kid doesn't come in and make noise. Okay, let's move on to the last rule here. Rule 3379, serving alcoholic beverages at fundraising events. Again, the idea here is to capture what is in our current advisory 26. So, we've kind of systematically gone through that and tried to say these are the kind of different permutations of situations that this could be and actors this could be, and then there are certain things you can do and there are certain things you can't do. So that's kind of the structure of the rule, and I would love to hear your thoughts about whether this all makes sense to you. And I don't know how many of you work with folks that have these kinds of events, but want to make sure that this rule is clear because I find that these rules are actually a little bit confusing. So I want to make sure that for the average user, you think that these are clear enough. Ms. Harrison would like for me to walk through the sections of the rule. So the rules, again, as always, I like to start with an applicability section. And we have, let me open up advisory 26 because that's going to help me explain where this came from. Thomas Graham would like to respond. If you could unmute him.
Good morning.
Amy, to address your question, so bulletin 26, right as of right now, has the three options that it talks about. One of those is where there's not a permit and a charity can give away donated alcohol. Then option 2 goes into a charity pulling the permit themselves, and then option 3 is how most sponsored events are done, where charity hires a third party to pull the permit. So this rule just kind of takes those and speaks about it from the point of view of the charity. So if you start at the top with B, an organization may provide free alcoholic beverages under the event without obtaining a permit. That's option 1 in the current bulletin. There is no permit. We just wanted to put it in the rules so that the charities had everything in one place to go and look and say, okay, so rather than looking for the bulletin number 26, all of the charities' options are in this rule. So whether they pull a permit or not, we tried to cover it here. So B is option 1, which is no permit issued. Charity can take donations. They can charge a door fee, all those things. And they can get sponsorship agreements, things like that. You go into D. D gets into the organization, the temporary, or the charity actually pulling the permit themselves. And that's the piece where we talk about, of course, they've got a permit, so they got to buy their alcoholic beverages through a legal channel. They can't sell donated beverages. And this is following option 2 of that advisory, because we go into in D3, the organization may not accept a cash donation from an alcoholic beverage member if it's got a written agreement that dictates how they're going to sell products, things like that. Of course, there's nothing that prohibits a charity from taking a donation of cash from someone, but a charity that holds a permit's a retailer, so he can't take a donation of cash in exchange for product exclusivity, things like that at a permitted event. And then when you jump down into F, F follows the way we set up major sponsored temporary events. So F is the charity goes out, hires that independent concessionaire, that retailer to serve products. That way the charity can engage in sponsorship agreements, signage, all those kind of things, and still have the retailer be an independent concessionaire at arm's length. And that's our typical big beer festivals, things like that. Does that help kind of lay out what this is? It's really just taking what we've practiced and what's been in the advisory and putting it in rule. Because that's something I think industry has pushed for a long time is, are you going to take these advisories and stick them in rule? And this is one of the ones where we're taking that language. And then there's also been an advisory update that's being worked on that'll come out down the road through the advisory process to kind of align with this and make it clear that that's what's going on, and then add anything new that people have requested over the years.
Thank you, Thomas. Mr. Schwartz has his hand raised.
Yes, Marcus Schwartz, Bracken Schwartz PLC. D1 talks about who organizations may purchase from, and I think this is a direct pickup from the advisory before these laws existed, but I don't know if you're meaning to preclude small breweries or brew pubs that can sell direct to retailers.
You're right that this is language that was directly picked up, and we are not intending to exclude those people, and they need to be added. So thank you for catching that, and we will make a change based upon your comment. And that's exactly why we have these stakeholder meetings.
Thank you.
And we'll also add package stores with local distributors. Okay, are there any other comments or questions regarding 3379? Okay, I'm not seeing any hands raised or any questions. Are there any questions about anything we have gone over today? I wanted to point out that if you're looking at that Chapter 33 table of contents for the proposed, the way that we want it to end up, you'll notice that, you know, we're trying to move a lot of things, and so the most efficient way to do that is to move them at the same time. Obviously, if we're going to repeal something from one place and move it to another, then we want to shift things into that place. So it's our intention to propose both of these in September so that we can, along with some of the other subsections that we're going to discuss tomorrow, so that we can make all those swaps of positions at the same time. And hopefully that will be efficient and less confusing for everyone. And again, we'll do full crosswalks so that those of you who have been practicing in this area for a long time will be able to easily find what you're looking for just by looking at your crosswalk. As always, if you think of anything else, please do not hesitate to send me an email. Let's see. Oh, here's a comment from Kyle Hill. Consider referencing Rule 45-111, which allows advertising signs at charitable events, in new Rule 37.9 that proceeds from signs advertising alcoholic beverages be received directly by charity or civic endeavor. Okay. Thank you, Mr. Hill. We will take a look at that. And Mr. Graham says we will be updating 45-111 down the road. I don't know anything more about that. We'll be updating all of Chapter 45. So that will be another big project in the future. Okay. As I was saying, if you think of anything else in the next month or so, definitely send me an email. My email is shana.horton@tabc.texas.gov. I am not in my office. I'm very fortunate that I'm able to work from home most days. And so the best way to contact me is email, because I'm not going to be sitting at my desk and answering my phone here. So that's definitely the fastest way. It's also ensures that I will get back to you. Is Tyler Rudd still on? I can scroll. Nope. All right. I was going to say congratulations to Tyler Rudd. I've known Tyler for probably 20 years, and he got married last weekend, but it looks like he's left the group. In any event, thank you all so much for your participation. We had almost 60 people here today, I think, at the height, and a lot of good comments. And I really appreciate you taking the time to review these rules at this point in the process. It's very important that we do these, make these changes early in the process before things get more set, while things are still very malleable and easy to change. So again, I really do appreciate your efforts in reviewing and in being here today to share your comments and questions with me. With that said, we will sign off for today, and I will hopefully see most of you tomorrow at 10 o'clock. We will be discussing, we have a very full agenda for tomorrow again. We will be discussing, here we go. A new subchapter C for bonds. That's a reorganization. And then we're also going to add in a few things that were part of essentially just kind of our working procedures that we think should be in rule. We're going to discuss the sanctions for regulatory violations. This is something we've discussed on numerous occasions before in stakeholder meetings since starting in, I think, January or February. And we are coming up on time to propose that, and there have been some significant changes to that chart based upon your comments and questions in the stakeholder meeting. So please do take a close look at that. We'll also be talking about the rules related to emergency orders, which will be new subchapter G in Chapter 33, and then the new rule for essentially safe harbor for consumer delivery permit, which is really essentially just restates what's in the code. There's not anything much beyond that. So that's what we'll be talking about tomorrow, and that's a lot to go over, so we'll have to move quickly, and I look forward to visiting with you all about that. All right, and we're signing off. See you tomorrow.